So what happens when two or more people agree to go to into business
Well,
together?
arguably, the first week they have a partnership. After that, they have incorporation once the documents can be filed properly.
Okay, and so they arguably have a partnership the first week because?
Because they hadn't received official notification from the Secretary of State that their incorporation documents had been certified and accepted.
So that raises issues of what?
There's either defective service or defective filing or no filing at all.
Now, one question I have about that is, this is that it's not de jure yet, corporation.
So we have the issue of de jure corporation,
But my
right?
question is, I thought from the reading that it was more like you send your stuff in and they mess it up at the Secretary of State. But in these two fact patterns, for the two different times we've seen, it's enough sometimes to present that the lawyer slowed things down. So
Right.
are we saying that that would qualify? It doesn't have to be something from the Secretary of State. It could be just the lawyer simply not getting the papers in as expected? Or is
Well, unless the lawyer gets the papers in as expected, and unless the articles of incorporation have been filed and have a stamp on them, you do not have a de jure corporation.
right.
So then the question becomes whether or not you've got some substitute for that. Okay, and the two major substitutes are what? Okay, de facto corporation and a corporation by estoppel, right?
Yes.
And we know that the approach of a de facto corporation is the actions of the people who intended to incorporate, correct? And the analysis regarding incorporation by estoppel is the actions of third parties. Those are the two major distinguishing characteristics. So, in this case, what do we have? What indicia do we have of a de facto corporation with Al and Bob?
Went to see his lawyer and filed and had made a colorable effort to file and left it with his lawyer. So that seems like that's the fact.
So they made a colorable effort to create a corporation. Okay?
And
They were
how do you define colorable in this sense? We've had in other classes used a little differently.
Okay, what's a colorable effort?
In the other classes, it was, you know, you thought things were done right, but they weren't. So you
Okay.
thought you had titles or something, but it was written in wrong or something.
Okay, so in this case, they thought things were done right. Right? They went to a lawyer, they hired the lawyer said he'd take care of it.
Good deal. They did everything they were supposed to do.
Right,
It's colorable.
right. So they made a colorable effort. The lawyer represented to them that he was going to file, and eventually did file, correct? It's just that he didn't get around to filing until after the lease was signed, I believe.
Right.
Right, a week later.
So the argument can be made that they made a colorable effort to create the corporation and that they acted as though they had a corporation because they were operating with the understanding that they had a corporation. And they represented to the outside world that there was a corporation. And they did that in good faith, with a good faith yet erroneous belief that the lawyer had filed. So there you're indicia for a de facto corporation. Now what about corporation by estoppel?
It has to do with what Dave, I think, thought that they were doing. His point of view, the guy who was leasing the property,
Right.
his outlook was that he thought he was signing on with an existing corporation. So from his point of view, he would be stopped to deny that he was dealing with a corporation because he thought he was.
Perfect. Okay, Thor.
De facto, we're kind of taking in the mindset and the actions of the promoter.
Correct.
Whereas a corporation by estoppel, we're looking at what the third party thought and relying.
Exactly. And you want to make sure that gets in your discussion. Okay? Yes, Bridget?
I think in the first one, you had it out, maybe somewhere in this one, you talked about a third method, but you didn't label it what it was, where the person who's doing the contract knows that you're not a corporation yet, but never intends to sue you, but has, kind of working with the corporation. It wasn't really a label to that.
Well, there is the concept of novation that you can have. If you recall a promoter, when a promoter, and what's a promoter once again?
Person who was
Someone that enters into contracts,
And
put together agreements.
an individual who signs contracts was in formation but not yet formed.
Okay, an individual who signs contracts on behalf of a corporation that's in formation but not yet formed, the promoter of the corp, is the person who decides, I want to create this corporation, and starts taking action to do that. Probably, typically the person who hires a lawyer to file the articles. And when a promoter goes out into the world and attempts to commit the corporation as a principal before the corporation exists, that's when you run into issues of defective incorporation. Now, if a promoter enters into a contract with a third party, and after the fact, is there any way for that promoter to get off the hook on liability to that third party after the fact? Well, ratification makes the corporation liable, but does it get the incorporator off the hook? No, Thor is right, it doesn't. But there is a way for that to happen. And the way to get the promoter off the hook is through novation. The novation process, and the novation process has the third party voluntarily saying, I release you, Mr. Promoter, from any further liability under the terms of this contract, and I agree to look solely to the corporation to satisfy the obligations of this contract. Now, novation is going to have to be in writing, and it's going to have those magic words where the third party releases the promoter from any further liability under the contract and agrees to look solely to the corporation for performance. So that would be your third method, Bridget? Okay.
I think Bridget was thinking of this, and the word isn't coming to me. It's not acquiescence, it's the one that's more active. When you accept something. The word's not coming. Is that what you're thinking of?
I'll find
The word
it,
you're looking
I'll talk
for.
to
Okay.
her.
I know.
You
Thor.
Authority, is that what you're
No,
talking about?
no,
I think you're thinking under just general agency or
No, it was just something, it was,
agency by acquiescence.
it was part of the
Acquiescence.
answer.
Acquiescence.